Any mention? Any mention?
My lord. Item number 26.
Upgrading?
My lord.
Upgrading?
No, my lord.
Oh, adjournment?
Adjournment. This is concerning disability pension, my lord. Disability pension, my lord.
No objection, Your Lordship.
Why? What's the reason?
My lord, whether the disability is a continuous...
What's the problem? Why is seeking adjournment?
My lord, some
What's the reading?
citation.
Okay. 2 weeks. Yes. On the pre competition. Yes.
Hello.
Yes, please, Lordship. Lordship, I beg to mention item 24, Lordship. Senior counsel has some difficulties today, Lordship. Kindly list this matter after 2 weeks.
Dismissal from service. Dismissal from service.
2 weeks.
2 weeks. Highly obliged, Lordship.
Please, please, Lordship, I beg to mention item 19. The conducting counsel is having some personal difficulties, so I pray for 3 weeks' time, Your Lordship.
3 weeks' time? 2020 matter. 2 weeks. Okay.
Your Lordship, I am appearing on behalf of respondent.
Your objection?
No objection, Your Lordship.
Yes.
Highly obliged.
Highly obliged, Your Lordship.
Main list, item number 1.
My lord, this matter pertains to the clubbing of the merit list of the clubbing of the merit list in a selection procedure where the scheduled caste and the scheduled tribe candidates were clubbed together, and the others connected matter, my lord has already issued a notice, and there was some defect, so I have withdrawn that.
You corrected next year 15?
My lord, I have corrected, my lord.
Is it corrected? Defect?
We received it.
Okay. Which other matter is there?
The other matter was
That is 271 minutes.
why you showed me this one?
WPC 271 of 23.
271.
271.
271.
Yes, sir. Mr. P. Yobin, you should notice the defects that have the defects. We should notice they submitted that the defects have since been cured. Mr. Essence present accept notice on behalf of
All the respondents.
all the respondents. List, when is that listed?
That is
Just
listed
together with
after-
WC
My lord.
271
My lord.
2023.
Obliged.
Supplementary list, item number 1.
Yes.
It's a contempt petition, Lordship, arising of the writ petition. Lordship, the
Arising-
writ petition, Your Lordship, had recused involving those clerical foreign officers.
Okay, this is matter before. In the bench wrote me, sir.
Item number 2.
Three and 4 are matters against the corporation for release of the financial benefits money. I may be granted about 10 days to get instructions.
Good, Miss. Your name, sorry?
B. Khasano.
P. Khar?
Khasano.
P. Kharsono. The conference of the petitioner. You should notice Mr. Essence present accept notice on behalf of the respondent. No further was called for. He prays about 10 days time to receive instructions.
Similar orders for
Yes,
3 and
yes.
4 as well. Sir.
Just after 10 days, yes. 3, 4 and 5.
3, 2, 3,
2,
4.
3 and 4 minutes.
2, 3 and 4. Same order. Yes.
5. Item number 5.
May it please your lordship.
What is this?
Lordship, this matter relates to one of these 5-star hotels which have come up in Shillong recently. This is the one in Jail Road, the Marriott Hotel.
Lordship, that project initially was taken up by another company, that is HM Cements. That was in 2010. So HM Cements entered into an agreement with the government in respect of that project. That agreement is important, my lord, at page 18.
Yes.
Page 18, my lord, is the agreement of 2010. The important clause, I would say, my lord, is at page 19, clause E.
Okay. Yes.
The lessor has agreed to provide to the sublessee the land free from all encumbrances, charges, mortgages, lien, court litigation, attachments, or any kind of charges. The lessor shall provide to the sublessee actual, physical, peaceful, vacant, and exclusive possession of the land parcel.
Yes.
So essentially, at heart, my lord, this agreement was a lease agreement. They called it a deed of agreement, but it was a lease agreement. Now, interestingly, my lord, if lordship looks at the first page of the agreement, no stamp duty was attracted, no registration charges were attracted.
It is lease agreement.
It's a lease agreement, but no stamp duty, no registration was attracted. Just 10 rupees stamp paper was paid. The reason, my lord, why no such duty was applicable is at clause A. The Urban Affairs Department is desirous of developing the plot of land on which the Shillong Municipal Board Office is currently located on build, operate and transfer basis under the public-private partnership method, more particularly, etc., etc. So this project was supposed to be undertaken under the public-private partnership PPP method. Lordship will be aware, my lord, under the PPP model, certain concessions, waivers, etc. are granted. We've attached the PPP policy. Relevant page, my lord, is at page 112.
Yes.
Page 112, my lord, the last clause, fiscal support, incentives and concessions. Government of Meghalaya will formulate sector-specific policies wherever required for providing specific incentives and concessions, as well as establish mechanism for tariff setting, pricing, arbitration, safety and operational standards, etc. So concessions were inbuilt or were provided for.
So you mean to say stamp duty is a concession?
Yes, my lord. On the next page, clause F. Clause F, that is foregoing of revenue streams.
Yes.
Concessions covered under the above category are as follows: concessions on stamp duty on transfer of land. So very clearly, under the policy itself, there was an inbuilt mechanism.
I don't think why on stamp transfer? There's no transfer here. By your own, it's only a lease.
It's a lease, my lord. So
There's
lease.
no absolute transfer.
So lease, my
Transfer
lord.
amount what?
My lord.
Transfer will amount to what in
Transfer-
context of this
transfer-
of your arrangement with these?
Lordship, transfer, strictly speaking, under the TP Act, Transfer Property Act, even a lease would be a transfer, my lord. So transfer of land, and very clearly, no stamp duty was paid because of this concession, my lord. Now, in any event, the original.
Does it say so in the deed of agreement that in view of the
there is no
in view of the concession as given in the PPP mode? No stamp duty is being paid on this
there
lease.
is no express mention of that. But
there's no express exemption also.
There's no express exemption, but the very fact that it was on 10 rupee stamp paper is self-evident, my lord. The fact that
so the styling is an agreement, so 10 rupees, yes.
Lordship, the heading of an agreement is immaterial as far as the interpretation of an agreement is concerned. In any event, my lord, HM Cements, the original contractor, could not carry out the project. HM Cements bought in another contractor, my parent company. Now, my parent company took up the project. My parent company went into insolvency proceedings before the NCLT Guwahati bench under the bankruptcy code, my lord. Now, NCLT, my lord, in 2019 passed an order. A resolution plan was approved. As per that resolution plan, my lord, new promoters came into the picture. New promoters incorporated a new company. Today's petitioner, my lord.
Specifically, the same name as the parent company?
No, slight differences.
What's the name of this company?
This company, my lord, is Maxim Infrastructure and Real Estate Shillong Private Limited. Okay. Shillong was not there initially, my lord. So this petitioner company was incorporated specifically with the objective of taking up this particular project. And naturally, my lord, the understanding or the expectation of the promoter was that the same concessions, waivers, etc. would also be available. Yes. Agreement was signed, a fresh agreement, my lord, that is at page 168. This agreement, my lord, at page 168,
Yes.
was executed on 19th October 2021, not registered immediately. But what is
Lease deed.
Now they call it a proper lease deed, my lord, without beating around the bush.
25 lakhs.
Lordship, I'll just
2,33,000.
Lordship, I'll just come to that aspect. But before that, if Lordship allows, clause 1.2 of this agreement, that is at page 171, my lord.
Yes.
The definition of the project itself. Last portion. Project shall mean development of the land parcel by way of development of modern hotel commercial facilities, including adequate parking under the public-private partnership in build, operate, transfer mode with all common equipments installed therein to be used for the purpose, etc., my lord. So the understanding was very clear that this project taken up by the new entity, today's petitioner,
Yes.
is also to be under the PPP model, my lord. Agreement was executed. We asked for registration and naturally, my lord, we asked for a waiver of the stamp duty. First, communication in this respect, page 198, my lord, Annexure 9.
Yes.
I'll just read 2 lines, my lord. We would like to inform you that we need to register the agreement signed on the so-and-so. The registration of the agreement is essential for banking purposes, and since the agreement is for the development of a 5-star hotel and falls under the PPP mode, we request your good self to recommend to the sub-registrar for the registration of the lease document without any stamp duty or registration charges. We kept on sending several representations. There was no immediate reply. Finally, my lord, at page 205, a one-line reply did come. I'll read, my lord. In inviting a reference to the letter quoted on the subject above, I am directed to inform you that the government regret its inability to consider to the proposal for waiving of stamp duty and registration charges of lease agreement. Rejection, no justification or reasons given, my lord. Subsequently, because of certain pressures that we were facing, we went ahead and paid the stamp duty and the registration charges. Page 207, amounting to page 207, my lord. Page 207. Yes, no.
25 lakhs along with registration.
It comes to about 29 lakhs 17,000.
Okay.
Approximately, my lord. So we paid it under protest, my lord.
Yes.
After that, we kept on asking for refunds, etc., adjustments, etc. Nothing substantial developed. We filed some RTIs, etc., asking for information as to on what basis was the previous agreement, on what basis did the previous agreement not attract stamp duty. No answers have been forthcoming. So this is the position as it stands as on date, my lord.
So you're seeking amendments for to refund your money?
Refund or adjustment?
Have you ever read?
It is permissible. The law is with me on this. The law is with me.
What's the law say?
If I can please it, my lord. This is from 2004, my lord, 2004 3 SCC. To 2004 3 SCC 553.
Yes.
Lordship, this judgment is important for the reason it deals primarily with disputed questions of fact and whether jurisdiction is the correct forum. The answer to that is yes. But with Lordship's permission, I'll just focus on one paragraph just to answer the query that has fallen from Lordship. Para 27, my lord.
27.
Para 27, I'll read, my lord. From the above discussion of ours, the following legal principles emerge as to the maintainability of a writ petition. A. In an appropriate case, a writ petition as against a state or an instrumentality of a state arising out of a contractual obligation is maintainable. B. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain.
But then that is all discretionary.
Lordship,
depends on the facts and some to each in particular case.
Lordship, clause.
Anyway, you
all I'm asking for at the moment is issuance of notice. Let them find a reply.
General issue notice. Who's present here for the government?
SI. SI.
It's present on behalf of all the respondents. No further notice called for. List after 3 weeks for instructions or affidavit.
Item number 6.
Motion.
Hello, this is regarding retirement benefit, my lord.
When he retired?
She retired with effect from 30th April 2000.
Only 30th April only come for writ.
My lord.
Did you prepare all your documents 6 months before retired?
Already, my lord.
Everything's in order.
Submitted, yes.
Everything's in order.
Yes.
And we heard Mr. Nsinkon issue notice. Ms. Tungwa accept this on behalf of all the respondents. No further list after 4 weeks. Yes.
Obliged.
Hopefully by the time will be processed. Yes.
Yes.
7.
Yes.
As the respondent has failed to constitute the election pregnant.
When did you file the election petition?
We filed it in the month of May.
May. Yes, where's my secretary?
Lordship is here, Lordship.
And
I don't see him. How we see it here?
we have also sent a reminder, my lord, on the month of
No, it's
July.
okay. They are bound to. And that's, you file under what, section 6? What's that?
Yes, my lord. Yes.
Yes. Where's my secretary?
Your Lordship is here,
The
Lordship
act,
is calling
it should
him.
have been within 6 months, it should have been disposed.
He's
Your Lordship, he's here, Your Lordship. He's just
gone for
outside.
tea.
No, Your Lordship.
Then
Lordship, this
heard,
is appearance, Your
heard
Lordship.
Mr. J. Shilla, issue notice, MS Sinong Khala Vice. Mr. Vijay Gandha, Special Counsel for KG accepts notice. Stop list after 2 weeks for instructions affidavit. Yes.
Main list. Item number 2.
Yes.
But in this case, I pray for another date because on a similar matter, we are filing another appeal. It's an analogous matter. So let it come up after a week, Malad.
Is that correct?
My lord, I do not know whether they are filing any other appeal, but I will just say one thing, my lord. After filing of this appeal, my lord, they have started going through a construction, my lord. Let us status quo with respect to the
Construction
property
where?
we maintain and
Here for whom?
I am for the respondent, my lord.
Respondent plaintiff, they had filed the suit.
Plaintiff.
Construction where?
Yes. Construction in the disputed property, my lord. So they are going on with the construction. It will create third-party rights, my lord. So let the status quo with respect to the property we maintain.
Is it correct? I undertake construction.
No, as per my instruction. Let the status quo order be there. I have no objection.
Yes, Mr. T.T. Dingro submits that as an appeal is to be preferred an analogous matter which will have an impact on the pending second appeal. He prays that another date be fixed. Stop. MS B. Goyal, counsel for respondent, however, has apprised, has submitted before the court that while the appeal has been pending, the petitioner or the appellant has started construction activities, which may create third-party rights. Like para interview the matter. This is matter on.
After 2 weeks,
After 2 weeks for consideration. Stop. In the meantime, status quo shall be maintained with regard to the property in question.
That's okay.
I'm so grateful, my lord. With me, my lord, Mr. Sukhdev also appears, my lord. Thank you.
Which Sukhdev, more Mr. S. Thapa, yes.
Item number 3.
Yes, Thapa.
Yes, also.
May I please, Your Lordship? In this matter, my lord, earlier, my lord, we was directed to file an affidavit to bring in record certain documents. So we filed that affidavit, my lord. But now, on the merit of the case also, we need to file an affidavit, my lord.
What is the affidavit you filed regarding?
That regarding that certain documents were delay, whether there was any application on delay, my lord.
Or correlation application?
Yes.
Same matter, yes.
Yes.
So
in
there,
this,
was
my
no,
lord,
there was no application?
no, there was application. We have filed an affidavit. So now,
yes.
no separate application. It was on the main application itself, my lord. Now we need to file an affidavit on the merit of the case also, my lord.
There is a direction. They are supposed to file it. They are supposed to file it.
Okay, let me, Mr. SD submits that though relevant documents have been brought to record by a short affidavit. It is necessary, but it's necessary that a full affidavit be filed with regard to the merits of the case. Accordingly, 2 weeks time granted.
3 weeks may be given.
3 weeks granted for affidavit by respondents number 1 and 3. Mr. E.G. Moment, present behalf of 1 5. Yes, evidence has already been filed.
Item number 4.
Your lordship.
Your Lordship, I'm praying for some more time as we've made some mistake with the annexures, so we may be given some time to correct. Your Lordship, for respondent number 6, 7, 9 and 10, we have already filed a response.
Only
6,
government.
7, 9 and 10, huh?
Only government have not filed.
Respondents 1
Why?
to 4.
When was this matter filed? 23.
Lordship, the affidavit
Any
is
urgency?
Actually, every matter is urgent. It's important, lordship. Actually, it's quite important, lordship.
Or a promotion proposed to UDA?
Lordship.
2 weeks time. Let's pray for is allowed further 2 weeks time to file affidavit after 124. It is submitted that the affidavit on behalf of 6, 7, 9 and 10 is already on board. No rejoinder to the affidavit filed by them. Not necessary.
Not necessary, lordship.
Don't ask next time then.
No, I just got to because still they are the main respondent. Government is the main respondent, lordship.
Yes.
5.
Applies, Lordship.
Your Lordship, our affidavit is ready. We may be allowed to file it
You
in the
spoke
course
some
of the day.
instructions today with regard to?
No, regarding some clarifications were required regarding the promotion to the post of chemist.
Lordship,
he was not selected by the DPC, correct?
No, Your Lordship.
Lordship, there is some urgency in this matter, so I
We'll
pray
file
the
it in
next
course
date
of
will
the
be
day.
fixed for final disposal.
Final disposal, very good. We'll be ready with the hearing. This court's always here. Any case final disposal, we're ready to hear it. Right now also.
I'll inform my...
You ready?
No,
We'll hear
yeah.
it. Yes. MSP Young AAG submits that the affidavit will be filed in the course of the day. This after 2 weeks for rejoinder of evidence.
Item number 6.
So I'm for the state respondent 1, 2, 3 and 5.
1, 3 and 5, yes.
We need some time to file a bit.
My lord, I have one information, my lord. My lord, we have asked for the regularization of the service of the petitioner.
Remuneration of?
Regularization. That was pending approval before the authorities. Now it has been approved, my lord. But we have not received yet the hard copy. I've got the soft copy with me. Just information on that.
What's your prayer here? Okay, Gini. Senior health instructor?
Yes, my lord.
You've not been regularized?
Regularized, my lord. Now,
Since?
Recently, my lord.
You been appointed since 2007?
Yes. Now it is regularized, but we have to submit the hard copy, my lord. I may allowed time. I think State Master.
What is the instructions?
Information.
Well, we are yet to get the instructions.
Then how come he already aware? He already has instruction that you don't have any? You appeared for the interview? to formalize your appointment.
No, that
because there's a kind of a system they put in place where even if you're recommended for regularization, then formalities that you have to appear before the interview board also.
My lord, one interview I was not allowed to appear because of the overage. But I was in service, continuously in service of that post only.
You're filing today the affidavit?
My lord, I'll be today will be filed. I just need a week's time. Just need a week's time.
What should we have just received authorised instructions?
You are for whom?
I am for respondent number 4.
Who's respondent number 4?
MPSC Service Commission.
That is the
MPSC, Secretary MPSC.
It's a post which is selected by the commission.
Yes.
Okay. Mr. A. Khan, GA for response 135, 1, 2, 3 and 5. Praise for the 2 weeks time. Similar prayer made on behalf of number 4. Both prayers allowed. This after 2 weeks for affidavit. Yes.
Item number 7.
For this.
As for affidavit, I'm praying for some more time.
My lord, I have an objection to that because the case is a seizure case, custom seizure case. I am suffering with them from 2017. The seizure was declared illegal by the tribunal. Battle. Seizure was declared illegal by battlers. Food test also was unauthorized and illegal. Thereafter, they come to High Court for customs appeal, that was dismissed. Thereafter, they went to Supreme Court, SAP was dismissed. So nothing survives. It is a tainted penalty. They may file the affidavit only for interest part. They should return the goods to me.
Goods are gone, destroyed.
They have illegally destroyed it. So I may be given seizure value of the goods. There is my humble prayer. Let them pay the seizure value, and for interest person, they may file the affidavit in opposition.
It's only second, 2 dates have gone, my lord.
Even then, my lord, from 2017, I am suffering. But drastically, I am suffering.
But the petition was filed only on
July, my lord.
Anyway, as prayed for the 2 weeks time granted to Royal Musica.
And I will file rejoinder if necessary. That can also be.
I pray for 3 weeks, my lord.
2 weeks enough, yes.
But with some instruction to come from headquarters.
3 weeks, there's no instructions. You already lost at all levels. What is there? It's only the quantum of how much you're going to compensate him for the seizure amount.
That's true, my lord.
As to what?
That's true.
Let the order come from the court. The seizure amount that will be given. Interest you can fight. That is the way things should be. There's no question of any more competing rights only for his, consequential rights and so on. 2 weeks, you tell them.
So I will file rejoinder within 2 weeks.
No, 2 weeks and 1 week for
1 week for rejoinder, my lord. Much obliged.
Yes, after 3 weeks.
Item number 8.
May it please your lordship. In this case, I am appearing for respondent number 1 to 6, and I pray for further 2 weeks time to file my affidavit.
What in this case is this?
Your lordship, there is an application seeking for substitution of petitioner number 19 who has passed away on 4/7/2023.
Number 19.
K1.
What's the case about?
Your lordship, this is with regard to the service matter where the petitioners are working for 90 days but their salary has been deducted and they are getting paid only for 89 days.
You're appearing for?
I pray for 1 to 6, respondent number 1 to 6.
Nehu.
Nehu.
Yes, take down a miss case first. Miss case number 185/2023. No objection for substitution.
Your lordship, no objection, your lordship.
She's the legal heir.
She's
the
the
legal
wife,
heir.
your lordship.
Wife. Okay. Miss case number 185/2023 in WC 197. This is an application for substitution of the writ petition number 9 by the applicant herein, namely one Srimati Juanita Juwanita Malingyang, who stated to be the wife of the deceased petitioner. What's the name of deceased petitioner?
K1 Young, your lordship.
Deceased petitioner K1 Young. Next matter, similar objected to by Mr. S. Roy on behalf of the respondents. Accordingly, the name of the applicant, Simiti so-and-so, shall be substituted in place of the writ petition number 19. In this case, allowed and disposed of. In the main case, in view of the order dated so-and-so passed in this case 185 so-and-so, Magistrate directed to insert the name of the applicant therein in place of the writ petition number 19. So, next paragraph, Mr. S. Roy plays that may be allowed further
2 weeks.
2 weeks time to file affidavit. So, praise allowed. Yes, after 2 weeks.
Item number 9.
I was required to file an affidavit. It's in the course of filing, my lord.
Yes.
I was required to file an affidavit, my lord, to bring into record the complaint petition. It's in the course of filing, lordship. I'm praying for a week's time for the matter to be heard, my lord.
23rd.
23rd.
What about the continuation?
Lordship, because we require a copy of that affidavit.
And
Without that, we
Mr.
can't
S.
file.
Deb submits that the affidavit you are directed to file will be filed on a causality. Yes, praise allowed. List the matter after 1 week. You supply copy.
Item number 10.
See on this.
Your Lordship, I'm pray for more time, Your Lordship, to file the affidavit. We've just received instructions.
What's the matter about?
This is regularization.
MSZ in now pays for a lot further. 2 weeks time to file affidavit. List after 2 weeks was also.
Obliged, Your Lordship.
11.
This is your lordship.
Yes.
Lordship, I've got the instruction, your lordship. So we'll like to file the affidavit, your lordship.
What's the matter?
Your lordship, the instruction is that, your lordship, the work order has been cancelled because, your lordship, there are two things, your lordship. The work order has already been allotted to the private respondent on 14/10/2022, your lordship, and that work also is now completed. Then another thing is that, your lordship, the person who issued the work order in favor of the petitioner, he does not have that power because this is a contract, your lordship. The original work order for this particular work, your lordship, is 7 lakhs. 7 lakhs. So the executive engineer, your lordship, he does not have that financial capacity to award any contract beyond 6 lakhs.
Not capacity, authority.
Authority, your lordship. So that's why, your lordship, that's why the impugn order is very clear, your lordship.
Where is it cancelled by mistake? This is the case.
No, your lordship, they said that it's due to overseas. My lord, what happened? I got an instruction even here that petitioner not even taking part in the tender. There is no even tender. There is no inviting
petitioner.
The petitioner, no, private respondent.
Then you say that.
Lordship, I'm so sorry. I apologize. That
Not
he said that
apologize to you.
even there is a guideline also for the issuance of the tender. Your lordship, they have never followed it seems. This there is the Meghalaya Delegation of Finance Power Rules 2006. There is a specific guideline is given that prescribe a revised guideline regarding the constitution and functioning of tender committee purchase. This was never followed, your lordship. And the private respondent who have not even applied for the tender, how we expected to get? There is a lot of manipulation.
That is not the case here, your lordship.
This is the case. I will prove, your lordship.
That is not the case.
Let them file the affidavit. I will counter it.
This also is also not true. So, your lordship, 0 plus 0 is equal 0, your lordship.
No, this all the document.
This also not.
This is the document issued by the government authority.
He's 0.
Yes, your lordship.
Number 4 is 0.
That is.
How come you awarded a contract to both of them? You awarded first to
I'm the third person, lordship.
For that,
there's another person also. They have cancelled. They said that work was not. Lordship, I'm so sorry.
Case won't improve by
lordship. Yes, lordship. I'm so sorry. My natural is to go. My submission, lordship. My submission is that I'm the third contractor. Actually, there was a Sanjeev Das was given first contractor, and they said that he was not complete within the prescribed period. So they cancelled the work order of Sanjeev Das, but that fellow, that Sanjeev Das, he was not before this court. And after that, on the basis of his cancellation, on the ground that he was not complete within the period of 30 days, they have
given to you.
Given to me. Then I have started, I'm constructing the work, and there is another order prior to issuing their work order. They have given that work estimate. Work estimate was given prior to the
So you spend money
final
from your
work.
pocket
I
to
have
do it.
spent more than 30 lakhs rupees.
And now given to another person.
Then they have given, and the 30% they are claiming that 50% work has been completed. The private respondent is claiming that 50% is actually it is done by the petitioner. Lordship.
Okay. Anyway, the note service report is complete. Response number 4. Can you take notice by person service?
Lordship, I will ask from the post office, Lordship, because
The
they
officer indicates that the service of notice number 4 is not yet complete. Stop. Mr. P. Samas praised the email out to obtain status report from the post authorities and file service affidavit stuff. Mr. Initial AAG will also praise the out. How much time?
That will be 3 weeks, Your Lordship.
Lordship, there is
2 weeks time to file affidavit.
I have a file in this case, at least to
Lordship, the work is complete, Your
not complete, Lordship, because as I said that 50% of the work is done by the petitioner, and now they have not even started.
Your Lordship, there is
The bills have been cleared on behalf of
Lordship,
number 4.
They are claiming the work
Lordship,
50%
also
is
there
done
is
by the
a-
petitioner.
There is a tampering also in the work order, Your Lordship. That will bring by an affidavit, Your Lordship.
Tampering of the work order cannot be done by the
work order
petitioner.
Has been issued to him is of 28, but it is enclosed in the writ petition showing the date of 27. Your Lordship. That will break by an affidavit.
But whatever the
after 2
document,
weeks.
All right, Your Lordship.
Item number 12.
Please, my lord. My lord, on behalf of the respondent number 2, an affidavit has been filed. My lord.
Your Lordship, I'm entering appearance on behalf of respondent number 1.
Yes, MS P.B. Sukama. How many respondents are there?
3, man.
Who's the appearing number 3?
Oh, I'm appearing for 2 and 3.
2 and 3. Mr. MS P. Usama has entered appearance today in behalf of number 1. As such services complete stuff. You haven't filed affidavit.
But I have filed for respondent number 2.
You already filed.
My lord, for 3 will be relying on the affidavit filed by respondent
Yes.
number 2. For respondent number 3, the affidavit will be relying on the affidavit filed by respondent number 2.
Usama submits that affidavit file. You already filed affidavit.
My lord.
The affidavit file on behalf of number 2 will suffice as far as number 3 is also concerned.
I pray for 2 weeks time, Your Lordship.
Yes, MS Vikrama for praise for the allowed 2 weeks time for affidavit. This thereafter also.
Lordship, the status quo order may be continued.
Status quo is there.
Lordship.
Yes, interim order when it shall continue until the next date.
Item 13.
Lordship, I have one more prayer. If I may be allowed to file a rejoinder to respondent
Of
to
course, yes, rejoinders as praise permitted to be filed by the petitioner to the affidavit filed by respondent number 2. Yes.
But item 13, I'm entering appearance for respondents 5 to 7.
That's all that means all of them.
Yellow.
Yes, Mr. P. Nongbri, today's entered appearance on behalf of respondents, private respondents number 5 to 7. Such service all respondents is complete. Yes.
Praying for time for instructions.
Some more time. The urgency?
No, Your Lordship.
No. Mr. S. Deb on behalf of 1 to 4. And Mr. P. Nongbri prayer and allowed how much? 3 weeks time to file the respective affidavits. Yes.
14.
Look, the grievance and the writ petition is that in terms of the orders passed in the last round, my lord, the municipal board has not taken any action. Recently, my lord, we have taken action, my lord, in accordance with law. The law will take its own course, my lord, for removal of encroachment.
Have you filed an affidavit? Where's the instructions?
I've not filed an affidavit. No, I've just received instructions I can bring these instructions by way of affidavit.
Are you aware of that?
Yes, Your Lordship, we have received a notice
Saying
saying that the municipal board has directed respondent number 5 to remove the slab.
My lord, I am appealing for respondent number 5.
he didn't receive the notice.
But I am entering the appearance today, my lord, so I
Yes.
need to seek his judgment.
Okay.
Nothing survives, my lord. Nothing survives. The law will take its own course, my lord.
Let's see. Are you agreeable to that?
Your Lordship,
What are
I'll
your
have to seek
instructions?
instruction, Your Lordship.
My lord, we have issued the notice to the private respondent, my lord.
You received the notice?
My lord, I have to seek his
You are Rajesh Deb.
My lord.
It was 17th August. That is just last week. Yes.
That is the grievance, my lord.
Philemon Nongri, Learned Counsel, respondent number 3 and 4, has produced a letter notice dated 17th August 2023, whereby the respondent number 5 has been directed to remove the cement slab over the drain and boundary wall erected by him. Stop. MS you are Paul Ardata. MS Ardata, who has entered appearance on behalf of 1/5 to the self praise. It shall have some time to obtain instructions. Stop. Calling this matter after 1 week to enable the petitioner respondent number 5 to obtain the instructions. Take this back for the time being. You can give her a copy also.
I'll give her a call.
If she accepts. Yes.
Much obliged.
15.
May I please, Your Lordship? Your Lordship, I'll be entering appearance on behalf of respondent number 4.
4? What about 6?
On the present correspondent number 6.
Number 6. 1, 2, 3 is state.
And 5, Your Lordship.
1, 2, 3 and 5, yes. 6 is? Okay, your name?
Jane Nazari. Your Lordship, I haven't filed the work life memo, so I'm requesting for the
We'll record it. What is your name?
Jane Nazari.
J. Nazari.
Yes, sir.
Yes, so Pasa and for number 4 has the number 4 and J. Nazari and Sumiti J. Nazari on behalf of respondent number 6 have entered appearance on behalf of the respondents number 4 and 6 respectively. Stop. However, Mr. J. Nazari prays will have to file a power in the course of the day. Where's your power? Is it with you?
No,
Are you
no, Your
Vakalat?
Lordship, I'm requesting for some time to file along with the affidavit.
She prays for and allowed. How much time? You file a power to file the power along with the affidavit on the, before the next date.
Number 6, she's out of station. That's
Before the next date, yes. What about state?
I'll be filing, Your Lordship.
Yes, MS Ailingba for what 1, 2, 3 and 5 prays for. Further, how much time?
2 weeks, Your Lordship.
For a 2 weeks time to file affidavit, yes. Stop. This after 2 weeks for affidavit by all the respondents, yes.
Item 16.
Lordship, this is a matter where the petitioner is seeking two remedy. There is a representation filed before the sheriff committee, and before we could take any decision or take a call, they have come by way of a writ petition, and of course they are asking for promotion. Promotion is not automatic because it is merit cum seniority.
It's never automatic. It's not by right. Yes.
Two remedy.
No, Lordship, last week they sought the instruction. Let them file the affidavit.
No, but is that correct?
No, it is correct. But the thing is this.
Your petition is very brief, it's only 2 pages.
Convention is that, Lordship, they are serially, they are promoting. In between some...
Conventions are not enforceable in law in India.
No, I understand, but the...
Only in Great Britain.
Yes, but in this, in the Forest Department of the District Council, they continue to promote on the seniority basis.
When are you retiring?
Another 4 years service is there.
On? You got 4 years left.
Yes, sir.
You don't enclose your representation here.
Page 32.
Yes, sir. Page 32. Actually 8.
So what decision are you taking on this?
We got a change in dispensation. The present EM in charge, I have already intimated. They will take a decision.
Then you, for the time being, what was the point pursuing this?
This is premature.
You filed representation only on, was nearly since December.
December, Lordship. 5th December.
Stop, take down, yes, the writ petitioner before this court with a prayer for being considered for promotion to the post of Assistant Chief Officer, to post of Deputy Chief Force Officer, which is presently lying vacant. Stop. Mr. PDA submits that the petitioner has been constrained to approach this court by way of the instrument petition, inasmuch as though representation had been filed as far back as on 5th December 2022, no action has been forthcoming on said representation. Next paragraph. Mr. V.J. Kantalanet, Senior Counsel, on behalf of the respondent, submits that due to the change in dispensation, the representation has been kept pending and no decision has been taken as yet. In this view, the matter representation is pending for the respondents. It is directed that this petition can be closed at this stage by directing the respondent to dispose of within
2 months.
Within 6 weeks. Within 6 weeks from the date an order, a copy of the order is served, is submitted before the concerned respondents. I kept pending honestly for affidavit earlier. Let them decide in 6 weeks. After that, you can come and the calling stands disposed of.
Item 17.
With above direction, between stands disposed of. Above noted direction.
It's a very limited period. I have filed these applications, and the last order court has passed. I'm just asking the government to seek instruction.
I have been directed to obtain instruction within a week, sir. But I'm still yet to receive instruction.
No, this matter may be disposed of because the managing committee passed a resolutions that we need to constitute an interview board.
If this court is very hesitant about disposing of these school matters from these.
No, school matter. I'm not asking any relief. Just mandamus to the director to dispose of that. That much. Let him take a decision. Either he's rejecting or accepting or giving approval or not giving approval. That is the case only.
If your lordship go to page 14 of their petition, they have submitted the resolution.
Your EM Sangma?
Yes, your lordship.
What are the instructions?
He said he has not received any instruction.
At this stage, I have no instruction, your lordship.
This case maybe I'm not asking anything. I'm just asking for disposal of that my letters.
Mr. M. Sangma submits
At
that.
least a week time may be given to me to obtain instruction.
By order dated 14/8/2023, given directed to obtain instructions within 1 week. The same could not be obtained due to couldn't be obtained. He prays and is allowed 1 week's time to obtain the same instruction. Just after 1 week or so and so. You obtain something.
Yes, sir. Applies to
Court very hesitant, Mr. Qureshi. With due respect, sorry. Because sometimes some innocuous orders pass, suddenly they all, it's like a hydra,
Yes, it happens, but
one person comes from here, comes from there.
But in my case,
all lawyers get busy filing the petition.
To take a decision only that much.
Yes.
Supplementary hearing, item number 8.
Lordship, on the last occasion during the course of
What
hearing,
records?
yes, you wanted to see certain documents.
Yes, Mr. Yes. Yes.
Appearing on behalf of
Yes, what happened?
Your Lordship is still engaged in another court, Your Lordship.
Register call the records have since been received. When we list it?
Can we list it next week also? It can be listed. Because
It's the matter. Tell your senior we'll list after 1 week. The records as requisitioned by order dated 8/8/2023 have been received. This is the matter on after 1 week. Yes. For hearing. Yes.
Main list, item 18.
Yes,
please, your lordships. So far I am concerned, my lord, I am done. Except, my lord, any reply request.
Statute is on legs, Your Lordship.
Where?
One of the
I don't know, one of them.
before Justice Dindo.
You can come back after some time, I'll be here. my lord.
Yes.
Come at the end of the board, Your Lordship.
Yes.
What remains?
He has, my lord, he has almost concluded, but even then your lordship said if you can improve, I mean.
Not conclude. I said don't submit only from the affidavit. Have some other submissions. Yes.
Yes.
Argue the matter.
So if he can, my lord, and if any reply required, my lord, otherwise I have done, your lordships. And only one thing maybe that 7th pay commission, my lord, that I got the clarification. And what are the number of teachers across, my lord, state, that information I got. So those things perhaps I'll take 5 to 6 minutes.
20.
Yes. Is that nectar matter?
NIT, madam.
Sorry.
But the new director is joined, my lord.
That's been a common refrain now for.
Joined since 7/8/2023.
August only.
August.
This month only.
So this matter has been pending for some time. Now, my lord, though there
No,
is
but
an interim protection given to them.
Can he effectively do anything in this matter, or he's bound by the directions of the higher authorities?
He's bound by the scheme. He's bound by the scheme.
But I was.
No. In this case, deviating from the scheme, whether those actions which you impugn he is bound by, he has to abide by them, correct?
But what I was trying, my lord, if we can place before the board, with my advice, my lord, if they can reconsider it.
We'll do one thing.
My lord.
This interim order is protecting you until further orders. So fine, we have to after 2 weeks we expect some outcome.
My lord.
Yes.
If no outcome, my lord, then
no outcome, we'll hear it.
The only issue is here, my lord.
No need to argue on the matter, Mr. Gautam. 2 weeks.
2 weeks.
If no outcome, then we'll hear the matter and finish it off. You know you're batting in a good wicket, so don't have to start slogging from now.
The only thing is that the petitioners are suffering on their career progression, my lord.
Okay, Dr. Mbozika submits that as the new director has taken over only on 7/8/2023. He prays the matter be taken up another date to enable the respondents to examine the matter in detail. Yes. Accordingly, this matter after 2 weeks for hearing. Yes.
21.
21. Same order.
Yes.
22.
Why did the hearing stop last time?
Your lordship has directed to file a note on with respect to the proceedings pending before the trial court.
Oh yes, we regard how many petitions were filed by you?
Yes.
Yes. No, one thing, Mr. Lindwa. What is like? Okay, fine. You filed Miscase 48 for what?
This is the injunction application, Your Lordship, which is still pending for hearing.
Now,
merits.
Defendant is Mr.
Yes.
Mansuri. Right. So now, fine. Fixed hearing of the miscase 48. Fixed hearing defendant for adjournment. Now this matter is stuck.
Yes, Your Lordship. With respect to miscase 48, which is an application under Order 39, I'll read it 151 CPC.
Yes, now 48 is its injunction application.
Yes.
Okay, that's just it. Because there's so many applications, that's why it's getting confusing. Okay, fine. 48, miscase 48 is stuck.
Yes, Your Lordship.
Okay. 48 of 2020 for injunction.
Yes.
Now, who filed application 658/2020?
I filed, Your Lordship.
This for?
A judgment on
That's also, it was miscase is also.
Yes, Your Lordship. It was not. It was not registered as a miscase, but petition has been numbered as 658 of 2020.
Petition for?
It's petition for judgment on admission.
Why you said judgment on admission?
Actually, they've been relying on my documents.
Okay. The next, what do you file? Next.
Then the defendant filed WS, Your Lordship, on.
Then he filed. No, file 8. Now see. Now what is this 8/4/2021 then? Defendant filed a written statement. In your first page. And this one you say again? 5/3/2021.
In accordance of the reflection of the proceedings in the case record.
No, actually I asked you to file a list of who filed what just to clear a confusion. Now it's more confusing. Now you say, okay, fine, look. On 25/2020, defendant was given last chance to file WS. 8/4/21, defendant filed WS. Then 8/3/2022, after 1 year, hearing miscase fixed. Now on 25/7/22, defendant filed adjournment. Okay, that's the eviction suit number 219 and the miscase. Okay. Next, then you filed an application number 65820 for judgment and admission.
Yes, Your Lordship.
Okay. Now, what WS is filed on 5/3/2021?
It was filed and registered, accepted by the court, Your Lordship, and the WS was registered as number 133 of 2021.
No. Then what's 8/4/2021?
There may be some error, Your Lordship, on this.
See, but there's no specifically court had asked to clarify.
Yes.
Because it's so confusing. How many the
record has been called before Your Lordship. So that's why, Lordship. So in accordance of what the record we have been able to obtain from the
record only.
Yes, we checked not from here, but it was from the trial court. So when we checked to clearly rectify on these dates, the record has been called before Your Lordship.
Okay, we don't understand.
Your Lordship allows me, I'll just make the picture a little clear. The eviction suit, my Lord, was filed on 11/7/2019.
Eviction suit number 2.
Yes, my Lord. 2 of 2019. The injunction application, my Lord, was filed on 10/6/2020.
Okay.
And it was numbered as 48 of 2020, my Lord.
Right, that okay.
Then,
that's clear.
In that injunction, my Lord, a status quo order was passed. That was passed on 15/6/2020.
That's not reflected in this note. Okay. Come again. Okay, fine.
2020, my Lord.
Let us start afresh.
Then, my Lord.
In this case.
Yes, it was filed on 11/7/2019.
2019?
No, the eviction suit, my Lord.
Yes.
Was filed on 11/7/2019. After that, injunction application was filed, my Lord, which was numbered as 48 of 2020 on 10/6/2020, my Lord.
10/6/21 or 20?
20, my Lord. 20.
20?
Yes, my lord.
Okay.
After that, my lord, on that injunction order, a status quo order was passed.
On?
On 15/6/2020, my lord.
Pass on?
15/6/2020, my lord.
5 days after it was filed?
Yes, my lord.
Okay.
Then the appellant were dissatisfied with that status quo order. Then they filed another application, my lord. This application was filed on 23/6/2020. Filed an application under section 114 of CPC for reviewing that status quo order.
Numbered as Miss Case 1?
It was not numbered, my lord. So an application under 114 CPC was filed on 23/6/2020. And on the
23/6?
Yes, my lord. 23/6/2020. And on the same date, my lord, the trial court has passed an order.
Order for?
The order restraining the respondent from carrying out business from the premises and also entering into the premises. That
Okay,
is what,
injuncting you.
yes, that is what their injunction prayer was. Now, against that order, my lord, I filed an application under section 151 on 7/7/2020, my lord.
151. Before whom?
Before the same court, my lord. On 7/7/2020 to vacate that.
On
7/7/2020.
7/7/21.
2020, my lord. 7/7/2020, my lord. Now, to vacate that order, which was passed by the court, restraining me from conducting the business or entering into the business premises.
Okay.
Now, that order, that petition, my lord, was dismissed by the trial court.
Dismissed, your petition was dismissed?
My petition was dismissed on 10/7/2020, my lord.
10/7/2020,
my lord. Against this dismissal, my lord, I approached the appellate court by filing an appeal, challenging the order.
10/7.
Yes, my lord. 23/6/2020, my lord.
No, 26/6/2020.
My lord.
You asked for recalling the order, correct?
Yes, my
lord. For review.
Yes, my lord.
For recalling order 151. That
Yes.
was dismissed on 10/7/2020.
Yes, my lord.
And against that, against the dismissal of 2020, you filed appeal.
Appeal, I filed appeal.
Okay. On?
I filed an appeal, my lord, on 13/8/2020, my lord.
13/8/2020.
And that appeal was registered as Miss Appeal number 1 of 2020, my lord.
As?
Miss Civil Appeal, my lord.
Yes.
1 of 2020.
What happened in the statement then?
No, that was in lower court, my lord.
Why didn't file in statement all along?
Because they have completely closed down my shop. I was out of the shop, my lord.
That doesn't mean you can't file in statement. Anyway, okay.
I could have filed, but then the process was, they have totally driven me out from the shop, my lord. So that actually compelled
So that under 151 was not registered as any miscase number?
Yes, my lord.
Miscase number 55, your lordship.
Miscase number 55.
2020.
What number?
55
Confusing.
of 2020, my lord.
Okay. Right.
Against this, my lord, I approached the appellate court. And
What happened after that?
Appellate court set aside that order. Set aside the order.
10/7/2020 order.
No, my lord, that order by virtue of which the injunction order by virtue of which I was driven out from the shop. The shop was closed. And that order was 23/6/2020, my lord.
23/6/2020. 23/6/2020.
I challenge
2020.
Yes, my lord.
20 order passed in your favor.
Yes, my lord. This order was set aside by the appellate court. 23 was injunction order, my lord, which was.
It's not the injunction order, yeah.
It was.
Lordship, it's a status quo order granted by.
No. 23. Trial court has granted status quo on 15/6. Then they were not happy with that status quo order. They filed a review.
No. You said just now 26. that section 114 application, status quo order was passed on 15/6/2020, correct?
No, my lord, 23/6.
No, status quo order passed when?
Oh, status quo order was passed on 15/6, my lord.
Right, and then they filed 114 application for review status quo order on 26/6.
23/6, my lord.
You said just now all
I'm so
confusing,
sorry,
that's
my
why.
lord. 23/6, my lord.
Just to navigate these dates and the application is, yes.
It was filed on 23.
And same day injunction granted.
Same day injunction granted.
Okay. Then against that you filed a 151 application for
150 for vacating that order, my lord.
Of 23/3.
Yes, my lord.
Rejected by order dated 10/7/2020.
My lord.
Now you file against the dismissal. You file an appeal on 13/8/2020.
My lord.
Right.
My lord.
And so and the appellate court set aside order 23/6 or 10/7.
23/6, my lord.
What happened to 10/7 order? What does 10/7 order say?
10/7 order, my lord.
Then 7 order, your lordship is stated because they are still relying on documents, which they ought to have filed the statement at that point, at that stage.
My lord,
So the
10/7
main
order.
observation of the trial court was that these are the main contention that lies with the suit. So rejection was on that.
No. It was absolutely wrong, my lord. The 10/7 order is there with me, my lord. This, if I'm allowed to read, it's a long.
See, the thing is that, Mr. Mansoori,
My lord.
if you file for vacation, the order 23/6/2020, rejected, dismissed on 10/7/2020, that order merges with 10/7/2020, it become the main order against which you will file an appeal.
No, against
10/7/2020 was set aside also appellate court.
No.
Then that order survives and 23/6 was set aside.
Against that order, I filed an appeal, my lord. Against 23/6. Against that order, I passed.
So what about 10/7/2020? You left
10/7, it was dismissed. My petition was dismissed under 151.
So
it merged with the.
Then where's the order?
Injunction order,
The
my lord.
order is there whereby when was the appellate order passed?
Appellate order was passed, my lord, on.
Just to navigate the facts also, just navigate the facts, I mean the sequence even so difficult, forget about coming to the merits of the case, yes.
The civil appeal number 1 judgment was passed on 10/9/2020, Your Lordship.
10/9.
10/9/2020.
So you filed on 13/8.
Yes, my lord.
2020 and registered in this case disposed of
On 10/9/2020, my lord.
10/9/21.
2020.
And what did the order say?
It set aside the order dated 23/6/2020.
What about order dated 10?
No, order dated 10 was not challenged, my lord.
How?
Because it merged with that injunction order. Because
No,
I filed, that injunction order was passed, I filed an application for vacating that order. Vacating that order, it was dismissed, my lord. Then automatically, my lord, that order merges with the previous order.
What kind of submission is that? Yes. Anyway, then what happened after that?
After that, Your Lordship, then they prefer the application, Miss Case 35.
Miss Case?
The present application which they have impugned in the civil appeal, in which I prefer the second appeal.
I don't understand. 55 is dismissed.
Then they prefer this application, Your Lordship, at page 119, Miss Case number 35 of.
No, after the appellate court set aside order 23/6.
Yes, Your Lordship. Then they prefer an application number 151, which is the present matter related with the appeal. Miss Case 35.
Facts little distorted.
100 and page 119, Your Lordship.
After this order, my lord, I was allowed to open my shop.
What order?
This appellate court order, my lord.
10/9/2020.
Yes, my lord.
Well, then what happened after
I
that?
opened my shop. Then what they did, my lord, they disconnected my electricity.
So it's independent proceeding.
Independent. Now they disconnected my
Case 35, Your Lordship. That is
they
correct.
disconnected my electricity. I had to approach the court, trial court, file an application for restoration of the electricity.
Miss Case number?
My lord.
35.
35.
Highly confusing. Okay, fine. Now what happened was, now 10/9/2020, setting aside order so and so, then let's say get disconnected.
My lord.
Then you file miss case number
35 of 2021.
Miss case number 35
Yes, ma'am.
of 21.
21.
For reconnection or for what?
For restoration of electricity connection in the suit premises. ma'am.
Okay. Then what happened after that?
After that, my lord, the trial court, considering the fact that it is an essential service, without dispensing with the notice, passed an ex parte order, directing them to restore the electricity connection in the suit premises.
Were they represented in the appellate court?
Then, my lord, what happened?
Were you represented in the appellate court when the order set aside? 36.
Yes, Your Lordship.
You heard, okay. So let's disconnect.
Then, Your Lordship, may I?
1 second. Defendant filed miss case 35 for restoration, policy connection in the suit premises before the trial court. Okay. Then when was the order passed by the trial court?
That was 17, my lord. It was 17/9/2021.
17/9.
Yes, my lord.
Order of restoration.
Yes.
By trial court.
Yes, my lord.
Yes. Then
they approached the trial court, my lord. They filed an application for vacating this order.
17/9.
Yes, my lord. For vacating this order, and trial court accordingly vacated.
Well,
Your Lordship, that's what. On this ground, they have brought new facts.
No. 1 minute. Let the facts be completed, Your Lordship.
Yes.
Let the facts be
Your
completed.
Lordship,
don't make arguments. Let's get
the reason why I filed my objection, Your Lordship, on grounds that they have mentioned of, which we have made it as part of question of law, with respect to which they have made a statement in connection with the Meghalaya Urban Control Act. They enclose the receipts and all. They enclose fresh documents, Your Lordship, without filing WS and without even relying on those documents which they have relied in the written statement.
There's no fresh
But the reason why we objected, Your Lordship.
There's no such.
Almost 1 year they did not file the written statement.
Now this has come on a total. It's on too many levels. This case.
Yes, ma'am.
Yes, Your Lordship.
See what happened. Okay, we just stick first to one road. Okay, there are many roads I've seen.
Yes.
Thing is that FC is disconnected. Defendant filed miss case 35/21 for restoration. Also connection before a trial court. Trial court 17/9/21 allowed for restoration.
Yes, Your Lordship.
And then you file what application do you file after that?
Application for.
After that, Your Lordship, they file an appeal.
No. It's not that way.
Immediately upon filing of the miss case 35, we file objection, Your Lordship. The objection.
No. Miss case for restoration, you file objection.
Yes, Your Lordship. We will file objection on grounds that the status quo order still survives. Status quo order in connection with miss case 48, which I have filed. And Your Lordship, they have brought in fresh documents here. They are relying on fresh documents which they have not filed written statement at that stage. Because in the course of which the document they rely, or they have any evasive denial of such, they should file by way of written statement. Lordship. And you clearly can see, Your Lordship, in page 120 that they have relied on the receipts which they have deposited before the Assistant Deputy Commissioner. Lordship. So I raised objection on that ground. So ultimately the electricity was restored. But
no.
With respect to how the electricity was disconnected, the court did not pass any order. But upon restoration of which the defect was found to be of technical defect. But it was not exactly of what has been made by the counsel for the respondent. Lordship. See, now, Your Lordship, the major facts that the bundle of facts connected with the case are being jumbled up by the application filed under 151, and there's no hearing has been made or conducted before the trial court, Your Lordship. And it has kept in hung animation of the entire
So you mean to say
process.
that this is very highly confusing.
Yes, Your Lordship. May I proceed, Your Lordship?
Yes.
And then, Your Lordship, we are in hung animation at present. So basically on the application which they have filed under 151, which in accordance with law should be resorted when there is no other remedy available. But they keep on resorting to 151 to take benefit of, to make the suit more pending and to occupy ad infinitum in the suit, Your Lordship. in the suit premises. Lordship. See, Your Lordship, in the matter of rent cases, ultimately I'm the owner. I need it for bona fide use. When I see that, Lordship, mental distress is there, Lordship. I'll somehow be affected by the nature of when I need it for that. So, Your Lordship, the matter of the fact concerned here, Your Lordship, is that the entire proceeding pending before the trial court needs to be decided by the trial court on the basis of the issues. Whatever there needs to be framed on filing of the bless. But the matter of concern,
one thing is, have you filed written statement?
I have filed.
They have filed, Your Lordship.
You objected to that also?
Yes, because they have filed beyond the mandatory period.
Is there any orders allowing them?
No, Your Lordship, there are certain applications which we have filed. The court has not yet passed any order.
For rejecting the written statement?
Yes, Your Lordship.
Filed beyond stipulated time?
Yes, Your Lordship. And we even filed an application for speedy trial, Your Lordship, on basis of the judgment of the Honorable Supreme Court.
So not in this case, so you filed speedy trial?
Yes, Your Lordship. Because, Your Lordship, I've said in rent cases, we have the mental distress and sometimes of the deprivation of the use of the property. So we prayed before the court, and that application also is still pending. So, Your Lordship, the matter of penancy before the trial court.
So what's pending for the trial court is your application for vacating the order of restoration?
No, Your Lordship, we filed for speedy trial and the objection for the filing of the written statement.
No, against order of restoration, you filed for recall of order also?
Yes, Your Lordship.
What's happened to that?
It's still pending since they have filed the appeal, Your Lordship. Then they
Appeal
prefer
what?
That's what he's not giving the full facts, my lord. So just to
see, last time we were hearing, we were back in square one.
Yes.
Last time was that's why this court asked us
He has not given the facts.
Sequence of the what applications were filed,
now the
what orders were passed.
The last
at least allow us to at least take up the matter.
Yes, my lord. Now here, your lordship has stopped to the point where the order of restoration was passed. Now what happened after that? He's not giving that picture, my lord.
He's saying
that he filed an objection.
In the appeal that I have preferred, which I prefer the second appeal now. I have appealed the order 7-10-2021.
Let me explain to the court.
7-10-21 is what order?
That's what I'm coming to that, my lord. He's not allowing me to come to that.
Okay, come to that.
He said that he's filed an objection against the restoration. No, it's not correct. He did not file because it was ex parte. It was ex parte order. He filed it subsequently to recall that order.
Okay.
And court ex parte recalled it.
Okay.
That ex parte order, recalled order, my lord, is on the 7th. That order is dated 7 October 2021.
Okay, okay. 79 order of registration ex parte.
Yes,
right?
my lord. Okay. And then that same order is recalled by same court.
Recalled on
7 October 2021.
7-10-21 on application
filed by the appellants.
Filed by
the appellants.
Okay.
Ex parte
defendants.
Right? Yes. Ex parte.
Then
against this order, my lord, 17, I went to appellate court.
Against 7-10-21?
I went to appellate court, my lord.
File what appeal they file?
Miss Civil Appeal, my lord. Challenging this order as to how ex parte this has been. Same court, my lord.
Miss Civil Appeal number?
7 of 2021, my lord.
Okay. Now it means against what happened? The electricity was cut again after that?
Electricity was never restored, my lord. They did not oblige to the court order in spite of giving them.
17-9-21.
Yes, my lord.
Okay, fine.
It was communicated to them. They did not comply. No, please let me complete.
To page 38, your lordship.
Yeah,
it was not. It was never an ex parte order. Your lordship, I'll read this. Heard the learned counsel for both the parties.
7-10-21.
Yes, your lordship.
Is that ex parte?
Page 38, your lordship. At page 38.
I was never allowed to participate. This order was passed behind my back, my lord.
Lordship, the court has clearly recorded his presence.
I
heard the learned counsel for both the parties.
But I did not. No show cause was called for. I did not file any show cause in this. It was decided.
What is it 24-9-21 then? See, page 30, heard the counsels. Both the parties have perused instant application, perused the order dated 17-9-21 along with order 24-9-21. After parole was passed,
fix for
ex parte.
9 for show cause. Send a copy to this to order ex parte compliance.
Right. Yes. And he never filed to show cause or miss case 48.
48, my
have
lord.
You filed now?
I have filed show cause and written statement both before the trial court. It is there on the record. But my lord, let me take your lordship to the order passed in Miss Appeal 1. That Miss Appeal 1 has set aside that order, injunction order. That has gone. 48 has gone.
No. You setting aside is a.
Setting aside, my lord, that order.
They did not file any prayer for setting aside, Your Lordship.
Order was passed on 15/6/2020, right?
My lord.
Then section 114 CPC application filed for review of status quo order on 23/6, whereas on same day then the injunction was granted.
Correct.
Right. So setting aside is of 23/6. So status quo order also goes, you saying?
No, status quo order, my lord. This order. No, status quo is there.
Then,
but this
injunction order given on 23/6 is set aside. You say?
Yes, ma'am.
Okay, we'll accept your contention that on 23/6 the injunction was given like not allowing to enter the premises. That was set aside. Okay,
yes,
right. Now, this court has held that. I mean, the trial court said that the status quo order is still operating. You see, it's not operating anymore.
Status quo order is there, my lord.
Then
that is there.
He said it's gone.
I have filed written show cause. I have filed written statement against that.
And in this case, 48 now still pending consideration.
That is only that part, my lord.
What part?
Status quo order. Because the subsequent part, injunction order, has been set aside.
My God, such convoluted facts. Anyway, so what happened to MCA number 721?
721, my lord.
It was allowed, Your Lordship. And the question of matter relates to.
Now, against 721, you filed an order was passed when? That you filed a miss civil appeal, right, on number 721.
My lord.
Against the order dated 710.
The judgment was delivered on 20th May 2022, Your Lordship.
Okay. 25, 22, MCA 27 allowed.
Yes, my lord.
And what is the order there?
That order has been. It says that the order passed by the trial court. This order my lord, 7/10/2021 is illegal and it says set aside.
That's it?
That's it.
Nothing else?
No, some observations are made.
What observations were there?
I will come to that, my lord.
So, the main case got derailed.
Yes, Your Lordship.
You got derailed completely and you're fighting for restoration. You never filed a statement in time.
Yes,
that show cause, that injunction matter, the main suit didn't proceed. The injunction matter didn't proceed. You're busy.
No, it proceeded, my lord. That's how the injunction was granted to them.
No other has been passed.
Injunction was granted to them, my lord, as they prayed.
Status injunction. That is, see, how can you see? Is any final orders injunction?
No, but then, injunction order was granted.
Granted is set aside. We revert back to status quo. That means that Miss Case 48 is still where it stands. It has to be. It's still under pending consideration.
But this process, Your Lordship, took a lot of time for filing appeal and then our disposal thereafter.
Yes, you fighting cases. I mean, I can't imagine. Is it ingenuity of the lawyers or the?
Yes, Lordship. In every hearing in the proceedings, Lordship, I place your objection. If they would have filed a written statement in time. If they would filed a show cause to the Miss Case, Lordship, then the matter would have proceeded. Then the entire decision of my Miss Case.
The thing is that
till then I should have been out. That is what he's
saying. No.
He's in his wild imagination.
There's no question of being out or in.
Listen,
Mansuri. The thing is that you failed to file a statement on time.
No, there is a reason for why I failed.
Eviction suit will file against you. It is a bond duty to file a statement within time. Correct?
True, my lord.
And if they file a miscase for whatever reason, they can't file for that you can't enter premises because you're in possession. That should have been brought by you before a trial court that you're in possession and let's see is there. Then it goes from there. Not that you don't file a statement, you don't file a show cause to the injunction application, then they get some order of status quo, they file for review, then you file a 151 for recall of the order.
Yes, my lord.
Then again it goes. Then the trial court vacates that earlier order. Or dismiss whatever.
It dismisses my application, and then I have given compelled me to file an appeal, my lord, against that order.
Compelled you to file an appeal because you're not. What do you call it? You're not conducting the case in a proper manner. How could you not? What?
Filed.
Your own conduct also speaks volumes.
Status quo order, when status quo order was given.
See,
my lord. They came with the application to.
Why didn't you file your written statement?
I filed it subsequently. I had to first protect my possession.
According to the note, you filed it when? Suit was filed on?
Suit was filed, my lord, on 11/7. 11/7.
And you filed your written statement on where the note?
I filed it on 21, my lord.
You filed it on, there are two dates you filed it, 8/4/21 and 5/3/21. Which date is correct?
I have to check, my lord, because these deeds are given by him.
I will not proceed the hearing now, please. At least you just put it in order. You give me just what has been given to the court today, just chronologically, what the miscase been filed for what and what orders were passed. Just a small brief. Then we can enter the merits.
And Your Lordship, I would like to seek permission to
You examine the records, yes.
Examine the record.
Instead of clarifying the matter, it's become more confusing.
I shall compile it, my lord. Compile it.
And he start fighting again before the court that his compilation is wrong, my comment is right. He'll say the same thing to you.
Let him compile, my lord.
Your Lordship, I need to produce
his
the
compilation.
report.
He's given 2 dates for his statement. Mr. Lingdo Ali's.
Your Lordship, we were not able to
Basic
access
thing
the case record as it's before Your Lordship. The record
You
has
say
been brought.
8/4/21 if I did a statement, again you say 5/3/21 if I did a statement.
Let me clarify on that, Your Lordship, then I need to produce the record.
Yes, though a note has been filed indicating the dates and the business and the various applications have been filed by the parties, including internal appeals, intra-court appeals, clarity is still yet, there's no clarity in the said note. Stop. The parties are permitted to examine the records and to set out a chart of events and dates. At least we know what appeal you filed, what order was passed, at least give a small gist.
I will give it. I'll prepare it. Let him prepare from his side. I'll prepare it from my side. 1 week. Short.
In a week's time, Your Lordship.
Yes, this after 1 week.
2 weeks, my lord. I'll
1 week, Your Lordship. The matter is pending for
No,
long
no,
time,
I'll not be out
Your
of.
Lordship, penalty
Okay, 10 days.
matter will just make me highly obliged.
Obliged. I thought that, the court thought at least today we could get somewhere and finish the matter. We'll get the note and, it'll be very clear as to what is the sequence of events.
I'll try, my lord. I'll try to do it.
She will assist the court.
Like being stuck in quicksand, Instead of coming out, you're going deeper inside.
23.
Obliged, your lordship.
Yes.
Your Lordship, the respondents were supposed to receive instructions.
Where's Mr. Zarika? There's nobody for the state. What's the matter about?
Your Lordship, this is regarding the release of pension papers, Your Lordship.
Release of?
Sir?
Release of?
Pension papers, Your Lordship.
Pension papers?
Your Lordship, initially the petitioner was employed as a chowkidar on a temporary basis, but then afterwards his service was regularized and he was treated as a regular worker. Then after, Your Lordship, he attained the age of 60 years in the year 2016 and he retired. Your Lordship, after that he did not receive his pension anymore, and then when he inquired from the department, he found out to his utter surprise that the pension papers were not released or prepared from the DMHO, in spite him being regularized.
Yes.
My lord, I just inquired from my friend that Mr. Hazarika is the counsel for the state. So, my lord, if any...
You have the brief with you?
No, my lord. I do not have any.
Your Lordship, as per the last occasion, the respondent state was supposed to receive instructions relating to the release of the pension papers of the respondent.
Ms. Zara is not here today.
My lord, I have not seen him today. That is in the order.
Let's see when was the additional affidavit filed. You got additional affidavit? What does it say? Oh, they said that your reservation was not without the approval of the competent authority. And that after you already retired, then the district election committee has no further role to play. Only if you're in service, then they can recommend for your realization.
But Your Lordship, the DMHO had regularized my service.
DMHO has no authority.
Yes, Your Lordship. It's not the competent authority.
So how will they regularize your organization, the procedure? The thing is that you were waiting for approval from the competent authority with regard to the case of the petitioner. Because the fact that he was working in sanctioned post, he retired against that post, and he, to his knowledge, the amateur regularized him. Now the stand taken is that that regularization was not without approval of competent authority, and so it is not considered regularized. And recommendation given by DSC was not recognized because he had already retired by then. He retired in 2016.
2016. My Lord, Lordship is aware that, my Lord, there was a cabinet meeting last year in 2020.
No, cabinet meeting is fine.
The cabinet, if this petitioner's name was also put up, then, my Lord, perhaps there must be some changes. His name must have been approved, and subsequently, my Lord, depending on the grade, my Lord, they have to undergo the interviews, either the District Selection Committee or the MPSC.
He already retired in 16.
But, my Lord, there was a criteria, my Lord, there were 4 criteria laid down by the Personal Department, my Lord. So each of the person who has been approved.
He died also.
No, Your Lordship, he's still very much alive. Your Lordship, as per that, the order that my learned friend is saying, Your Lordship, his name is already here, reflected here.
Then, my Lord, if I may humbly submit, my Lord, there was a criteria laid down by the government, my Lord, there were 4 criteria. Each of these incumbent whose name were approved by the cabinet meeting, my Lord, they have to undergo interviews, my Lord. In the sense, my Lord, they have to bring the documents, those will be verified.
Right. But then how will be verified now? He's already retired.
My Lord, that portion, I don't exactly know the procedure, but then that was what on the record.
See, you see paragraph 4 of your affidavit, first affidavit. You show MS Kolni, the affidavit filed by the state respondents, the first one.
This is the first affidavit. Respondent number 5. Business with our teachers. Yes. We didn't look at. Which year is this, please? 2022. My Lord, if it's a limited instruction that has to be taken, my Lord, then I can speak to the department concerned and, my Lord, and have this matter. And I also inform Mr. Hazarika also, my Lord. I'll make a point from my side also.
Mr. Hazarika, lastly didn't appear also. See, appearing for government is not that you're doing legal aid also. I was the government counsel for a long time. It's not that you're doing legal aid that the other priorities are there. You have to equal a priority to all the cases. You tell your panel advocates that. Sometimes they don't appear just on a whim if they have some other pressing matter. Court will note that also because that's the thing. Yes, Mr. Aziz Zareka, the conducting counsel for the state respondents, is not present in court today, and no adjournment has been sought on his behalf. MSR Kohli, who is present in court, has undertaken to take up the matter and to obtain SC instructions.
My Lord, undertaking to take up the matter will not be proper for myself.
Why?
Because, my Lord, this matter has been officially assigned to some other
Also undertaken to obtain instructions, yes, in the matter. Just after 2 weeks. Yes.
My Lord.
Right. 25.
Please, Your Lordship. Can hear the matter, my Lord.
Yes, start.
Lordship, by way of this writ petition, my Lord, we are challenging the impugned order dated 16/8/2022, whereby the petitioner has been asked to vacate her house and from the land.
Who's appealing for the Police Control Board?
State.
There's no.
Is it noticed by whom? You have Darbar Stamp Hitarshi? Okay, yes.
District Magistrate is there.
Yes.
A notice has been issued on 16/8/2022, Your Lordship, whereby they are asked to vacate the land and the house within 15 days. And on the expiry of the 15 days notice, the house shall be dismantled, my lord. If I may take your lordship to Annexus 7, page 29, which is the appeal notice passed by the respondent number 3, District Magistrate.
Yes.
Now, to the petitioner, my lord, subject eviction notice. Whereas a letter has been served to you, number general so-and-so, dated 5th July 2022, requiring you to show cause regarding the construction of your house within 50 meters from the Mintadu River. Whereas your reply on the matter is insufficient and that you have not offered any valid reason for violation of the order. Now, therefore, in compliance to the order of the Honorable National Green Tribunal in OA number 172/2016, dated 16/7/2022, you are hereby directed to vacate the premises of the said building within 15 days from the date of issue of this notice. Take notice that your house and structure standing within 50 meters from Mintadu River shall be dismantled after the expiry of 15 days notice, my lord. Now, if I may take your lordship to the brief facts of the case first, my lord. Now, the brief facts of the case, my lord, is that the petitioner is an owner and possession.
Now, one thing, Mrs. Sean, where is that order dated 16/7/22 of NGT? Is it anywhere here in the record?
No, my lord. We also were not aware of that order. They have never enclosed that order.
You can collect it. This is original application number 172/2016. You can download that order.
We have not, my lord. I've tried once, but we cannot
You
find
cannot obtain it. Why?
No.
You don't have it with you also.
Even the government also, they have not produced that.
No, but you're basing your notice for demolition on this, on the order that it has to be here. That is order says so and so.
Now, my lord, if they are taking the contentions, relying on the order
that's not the contention. That is the entire impugned notice.
Yes, my
is based on that order. Yes,
based
where's
on
the
that
order?
They have relied, my lord.
I'll provide.
You produce it.
Yes, Your Lordship.
1 OA 172 of 2016. How would the DC issue such order without? How would the petitioner be aware also?
We are not
what's
aware.
happened in NGT, because otherwise.
Your Lordship, there was a meeting which was conducted.
Where's the letter? I mean the order. Sorry.
I have not enclosed the order, Your Lordship. I'll produce on the next date.
Why you don't have it with you? See page 23. Mr. Songwan.
This is the first notice which they have relied based on the order of the NGT.
See which Sajid Lalu was still Meghalaya.
Yes, man. I'm not the party.
He's a resident of Juwai. Ask him where the order.
My lord.
Yes.
I'm not the party in this instant case which they have challenged before this NGT.
No, you're not a party, but then once NGT orders are passed, it applies en bloc,
Yes,
like to all constructions. Even now, this court also has issued some directions regard to construction in water bodies. So that's the kind of thing. See, now your house at what distance from the river?
They have said that it is within 50 meters.
Yes, I mean what exactly is how many meters?
According to this notification which they have given here.
Did they do a physical verification of the location?
They have said that they have already conducted the physical. But I was not present also. I was not called for during the inspection, my lord. That is also another point of contention that we are lying here. How did they come to the conclusion that my house is well within 50 meters also, my lord? We are not aware.
Environmental matter. You produce that order.
Yes, Your Lordship.
In the course of hearing, it appears that the impugned notice dated 16/8/2022 was passed pursuant to an order of the National Green Tribunal dated 16/7/2022, passed in O.A. capital number 17/2016. The copy of the order, however, is not available before the court today. MS Ailingwa, that is GA, for respondents 1, 2, and 3.
1, 2, 3, Your Lordship.
Please, we have to produce the order on the next day of hearing. This matter up to 1 week.
My lord, going through the notice, it seems that there are two orders passed by the NGT. in this letter dated 5 July 2022.
You get whatever is there, you will see.
Order 5 is there, my lord.
Yes.
Obliged.
Whether it applies to you at all, we have to examine that also. Your grounds should have been there, so whether it applies to you at all. Now, by saying you're not a party there doesn't mean, but whether that order, that notice is there, you have to check whether order applies to you or not.
Can be a judgment in can.
Yes, it can be whatever. Yes.
27.
Wait, please, Your Lordship, learned DSGI is praying for some accommodation in this matter, Your Lordship.
Where's the petitioner?
Your Lordship, she was here a while back.
On a prayer, Ms. Imruthava is also due to the possibility of the DHCI just after 2 weeks. This is 22 matter. Oh, she is here. Yes. Record Picheti's name. They're not willing to take up your hearing.
Actually, I was ready, Your Lordship, today also.
You pay her cost.
No, Your Lordship, sir.
No, okay, that's fine.
18.
If they object, then you have to give cost.
Second call 18.
Alot, na? Huh? Where's your opponent? He's hiding.
I don't think so, Your Lordship. May be engaged in another court.
He's here in court.
I have seen his justice at the church.
Come, display board's not working. Why?
In that case, Your Lordship can kindly place this matter after a week.
Yes, on second call, Mr. Kiwi Bharatchaji, Lanaji is stated to be still unavailable. Stop. In that view of the matter, this is a matter after 1 week for him. Because I don't want to keep it pending. The thing is, just forget everything.